Judge,
Yep.
next case, if we can take up John Hanna.
Is he in jail too?
Yeah, these are all in jail, yes.
Okay. They show one on John Hanna. Is that what you show?
Mr. Hammond.
I'm sorry, Judge, I didn't hear you.
You have just one case on John Hanna today?
Yes, Judge. Yes, Judge, just one case.
We are on the record in 2024 CR 420, State of Kansas versus John Raymond Hanna. Please announce appearances.
Jerry Regier on behalf of the state.
Your Honor, Darren Patterson, appear on behalf of John Hanna. Mr. Hanna does appear via Zoom audio visual from the Butler County Jail. Judge, this is a case where I am requesting the court to allow me to withdraw. I would just tell the court that communication has broken down to the point where counsel and client are not able to discuss the case any further, and would ask substitute counsel be appointed, or Mr. Hanna may hire counsel. I don't know.
Mr. Hanna, are you able to hire counsel?
I'll have to look into it, but I'm pretty sure I can figure something out.
Well, if you can hire an attorney, you should hire your own attorney. But you apparently told me or someone else that you couldn't afford an attorney early on, and you received court appointed.
No, I was saying that I have been in court. I've been pretty much in a situation where I was supposedly incarcerated, to where I haven't been able to contact my family members. What I explained. That's how I explained that. I don't like contacting my family members from facilities like this. Because I had problems stealing my mail and identity theft, so I don't really condone talking to my family member and giving our address in a situation like this with these people that don't have what they call a 922E or a 912E jurisdiction. So we can continue on if you want to try to. I just adjust jurisdiction right now.
Well, what in the world is a 912E jurisdiction?
I'm the judge. You're supposed to figure it out. I'm telling you for.
I can't figure out something that doesn't exist.
It does exist, but I'm saying if you don't exist, I understand. If you don't know, I mean, it's not my fault.
Today we're diving into not one, but two sovereign citizen courtroom appearances, and the first one? Well, you might remember him. This is a follow-up to a man who previously treated a courtroom like it was an open mic night at a conspiracy convention. Now he's back, this time in custody, and things spiral almost immediately. We've got a judge who's clearly not new to nonsense, a defense attorney waving the white flag before the hearing even gets going, and a defendant who believes he's uncovered secret federal jurisdiction codes that apparently no one else in the state of Kansas has ever heard of. He claims the court is corporate, financed by the feds, and somehow operating illegally, all while sitting in a county jail on misdemeanor charges. But here's where it gets interesting. The more he talks, the more he convinces the judge that this isn't just defiance, it might be a competency issue. And when a sovereign citizen accidentally talks themselves into a psychological evaluation, that's when the real plot twist begins.
Well, it is. If you're going to bring something up that I'm not familiar with, you're going to have to tell me what it is.
No, it's jurisdiction. I mean, you have to look it up. Everything you hired a counsel for me. You hired a counsel for me, and this dude is over here like supposed to be the. I mean, and then and the other thing, dude told me that the court that he said it was going to be 3 days from now. He didn't say it was going to be today.
Who told you that?
He did. The attorney did.
All right, Mr. Regier, do you know what this? Tell me that number again. What is that number you're citing, sir, for jurisdiction?
922E.
920.
And you got a 912E too.
And a 912.
Yeah, that establishes that the corporate courts are illegal in the United States, pretty much.
Corporate courts are illegal?
Pretty much illegal in the United States, yeah. Pretty much.
Okay, that's...
On the Brady violation as well. Maryland versus Brady.
I know Brady.
Yeah, Maryland versus Brady, yeah. And when we addressed this issue, you should have started with Maryland versus Brady. When you addressed me before anything, you're supposed to address me with Maryland versus Brady.
All right, stop it right now. I'm not going to keep taking your abuse.
Okay, I'm not going to take abuse. I don't want to lock no handcuffs on.
All right, you're gonna
My
stop
residence.
it. You're
My
gonna
residence.
sit him down and you're gonna show respect for the court. You
Show
have
respect.
a
It's my
very,
house.
stop it right
My
now.
house. I built it. Whatever. I built it.
Well,
I paid out this bill. This place.
you will stop it right now. I
Whatever.
understand we have a screen
Whatever.
between us.
Yeah, okay. I know we have
You're
screen
not
between. I
helping
don't even know if you're in
yourself.
the courtroom for real. Let's do a video.
Well, I think I understand why Mr. Patterson, a very experienced, very competent, qualified attorney, can't
I
work
got
with
one.
you.
I got a couple of them too.
Well, if you got them and you can afford them, there's no reason the taxpayers ought to be paying for your attorney.
I pay. What do you mean? I'm the taxpayer that pay for my attorney. Point blank. Quit telling my intelligence, please.
Well, I'd order them to take you into custody, but you're already there.
I know I'm in custody, and you went up on my bond in custody. What is? How you do that? Oh, that's part of the justice right there. Thank you. Are there any more things to issue, Mr. Jay? What's the
You
prosecutor's
will
name?
address me. You're, stop it. Mr. Patterson, you are most definitely excused from this case for the reasons cited. You may journalize the dismissal.
Yes, Judge.
And I don't see any need to point anyone else because the defendant's telling me he can afford an attorney. You just need, what do you need to hire your attorney?
Let me figure it out and I get to it. I don't like to make rush decisions, especially in handcuffs.
Right out of the gate, we've got a major red flag. When a defense attorney, especially one described by the judge as experienced and competent, asks to withdraw because communication has completely broken down, that tells you everything you need to know. Lawyers don't just quit midstream unless something is seriously off. And listen closely, the attorney isn't blaming strategy disagreements. He's saying they literally cannot discuss the case anymore. That usually means the client refuses to cooperate, rejects legal advice, or insists on pursuing arguments that have zero basis in actual law. And if you've watched sovereign citizen cases before, you already know where this is headed. The judge now has two issues: keeping the case moving and managing a defendant who thinks he knows more than everyone in the room. Buckle up, because once Mr. Hanna starts talking about 912E jurisdiction, this hearing takes a sharp turn into fantasy land.
All right, Mr. Regier, have you ever heard of this?
Thank you.
What he's talking about?
Behind him too.
Stop talking. Do you, Mr. Regier? Mr. Regier, do you know what he's in reference to when he says 922E jurisdiction and 912E jurisdiction?
Wrote everything backwards.
Judge, I think those are pursuant to federal rules of procedure.
Definitely.
Well, we're not in federal court, so I don't keep
But
myself.
you have to go by my constitutional rights for a due process. For to be a corporate court, it could, because you're financed by federal money. This is not financed by the people here in this county. You get government grants to run this place from the feds.
Where in the world did you hear that?
It's the truth.
Where'd you hear it?
I don't matter what I heard, because I do my own research. I'm not answering that question. I would plead the fifth on that question.
Well, I don't know what he's talking about.
Exactly.
It's a federal rule, but this is not.
So we can bring up the competency of the court right now. We'll have to turn just on that. Do we need any issues, Mr. Prosecutor? The Department of Justice gonna be emailing you pretty soon.
Sir, let me explain something to you. You are in the district court, 13th Judicial District.
For misdemeanor accusation.
State of Kansas. This is not federal court.
I understand federal court.
The rules that apply are the Kansas statutes annotated. Yes, the Constitution applies, but you're not citing Constitution. You're citing apparently federal rules of evidence that apply in federal courts, not in Kansas.
No, that doesn't apply in federal court. It applies to a state because it goes with Maryland versus Brady.
Where did you get your law degree?
You don't have to have a law degree. Doesn't matter about that because I've been educated by the best attorneys in the United States. One of them is I happen to be real close to one of their daughters, a few of them, and their sons, and I personally know a U.S. Supreme Court judge as well.
And here it is, the magic numbers: 912E jurisdiction, 922E jurisdiction. Notice how confidently he says it, like he just unlocked a secret legal cheat code. The only problem? The judge has never heard of it, because it doesn't exist. This is textbook sovereign citizen rhetoric. They throw out legal-sounding phrases, misquote case law, and rely on the idea that if they sound official enough, maybe the system will crumble under confusion. But courts don't operate on vibes. They operate on statutes and procedure. The judge does exactly what a judge should do. If you're bringing it up, explain it. And Mr. Hanna's response? You're the judge. You figure it out. That's not how burdens of argument work. If you claim a court lacks jurisdiction, it's your job to prove it. Instead, he doubles down, and that's where credibility starts evaporating fast.
Definitely.
All right, so this time is going to count against you so that you can get a new attorney. And you told me you are going to hire your attorney. Is that right?
Yeah, I said I will figure it out. Is what I said.
All right, so you'll figure it out. You don't want the court to address another court appointed, right?
Pretty much not. Not with that competency level.
Not a court appointed attorney. So let's have the notes reflect. He does not want a court appointed attorney. He questions the competency
Yeah, I'm
level.
going to go after the prosecutor now.
Oh, you want to go? You said you want to go
against prosecuting. Thank you. Say put that on the record. Terry Clark got never forgot on paper. Thank you, Mr. Prosecutor.
So what did you say? You want to go after the prosecutor?
No, I said we will holler at the Department of Justice. We'll talk to him. Go after his accusation. Is what I said. Confirm his accusation with the Department of Justice. That's what I said. Thank you. Is there anything else I can get back to where I was legally incarcerated at?
Deputy, do you think that does he normally behave competently? I'm wondering if I need to do a competency evaluation. Anyone want to be heard on that?
I've already had one.
In this case, you have?
No, I have one on my federal case. I felt competent because everything I say it's already backed by law.
Well, I am going to, on my own motion, order that there be a competency evaluation. That can be done in the county jail because I'm not sure you're tracking, Mr. Hanna.
Good for you. I don't care if you think that or not because I can decline it. I can decline that. And if I'm found incompetent, that means you can't do what? You can't put me in a court of law. So you just made another mistake.
Well, if you're found to be incompetent, you will go to a state security hospital.
No, I'm on it. You can't legally commit me to a hospital.
Yeah, I can.
No, you can't.
There, yes.
No, you can't. That just goes to show you try to commit me to that's illegal. You can't do that either.
Now we've shifted from fake procedural codes to the classic corporate court conspiracy theory. This is a common sovereign citizen belief that courts are secretly corporations, funded illegally, and therefore lack authority over living men. It sounds dramatic. It sounds rebellious. It also has zero legal foundation. Notice how the judge doesn't lose composure. She simply states the obvious. This is a Kansas district court. Not federal. Not corporate. Not a secret maritime tribunal. Just a state courtroom handling a misdemeanor. But here's what really stands out, the escalation. He's interrupting, demanding to be addressed a certain way, accusing the court of misconduct, all while asking for relief from the very system he claims is illegitimate. That contradiction is the hallmark of these arguments. If the court has no authority, why are you asking it to rule in your favor?
Well, he's set for jury trial this week. I'm going to continue the jury trial because he needs a new attorney. The time will count against him.
So they have to do illegal commits, take people's property, identity theft. Yes.
And we need to do a competency evaluation. We will set this over. When's my next available jury trial date, Jen?
February 23rd for the pretrial, February 25th and 26th for the jury trial.
You said 26th, and did you say 25 and 26?
That's correct, Your Honor.
Okay. All right. So the defendant is ordered to be here February 23rd for pretrial and February 25th and 26th in person for a jury trial. And then when I get the motion on file for competency, then we'll set the competency hearing before then, of course. I see you have had a U.S. Marshal hold on federal charges. That was back in April of last year. I see there was a previous failure to appear.
I was in Butner on evaluation because I had to get rid of the last attorney I had. His name he was going under a fake name. His name is Kurt Burrows, and his name is Beeman. So I had to remove from my case because he wasn't even who he said he was.
Well, I don't know.
Party mistake. Yes, I conflict of interest. Yeah, I've had to remove from the case.
Well, I don't know either of those names. That must be on your felony charges.
Yeah, felon possession firearm, which I got a settlement on. Then I got a settlement when I was in federal prison for it. Got a settlement for it. I've been illegally detained. It's in the law book.
And I see your first appearance, 9/6 of 24th. You were found to the court at that time. I think that might have been Judge Satterfield. I'm not sure. Found you very combative and challenging jurisdiction even then. Oh, it was Judge Sanders. That was retired former Chief Judge Sanders. Okay, former Chief Judge Sanders. All right. Well, I think everything is resolved. Anything else, Mr. Regier or Mr. Patterson, we need to address on this matter?
Your Honor, more of a point of clarification. If the court is ordering a competency evaluation, the state will be requesting clarification as to who has prepared the appropriate journal entry.
If your staff has those forms available and wants to do that, that would be fine. If not, I'll have to do it myself.
Very good, Your Honor.
And Judge, I'm out of the case, of course, but I think Mr. Regier knows that it's supposed to be the local mental health department that does the initial evaluation.
Yes.
The state is well aware of that, Your
Okay,
Honor.
thank you.
There's conflict of interest. He doesn't want interest.
Where's the conflict of interest, sir?
The prosecutor cannot give me he cannot be the one that gives me a competency hearing because he doesn't have he's the one accusing me of something. He's the one that brought up the charge, so he can't be the one in charge of my mental competency hearing because it's a conflict of interest. It has to be somebody who has my interest.
Well, I don't have your
or somebody that's subjective to it. Objective point of view, it can't be him.
Okay, well, I'm the one that is ordering the competency evaluation. He just has the staff to do the paperwork, but I'm the one ordering it.
Okay, so, yeah, you shouldn't have said that though. It's on record.
All right. Well, all right. That's the order. And Deputy, please, I'm remanding him back to your custody, the custody of the sheriff, to take him back wherever you.
Yes. The phrase that has launched 1,000 conspiracy theories. I do my own research. When pressed for a source, he pleads the Fifth. That's not how the Fifth Amendment works, by the way. It protects against self-incrimination, not against being asked where you got your information. And listen to the logic spiral. He claims federal funding equals federal jurisdiction. That's not legally accurate. Courts receive funding from various sources, but jurisdiction is defined by statute, not by budget spreadsheets. Then comes the name dropping. He knows Supreme Court judges. He's been educated by top attorneys. These statements aren't arguments. They're attempts to create authority by association. And the judge? She sees right through it.
Okay, I didn't know.
He's not disposing who he is
Religious. This is now a religious experience. You have a belief.
now. Yes.
All right.
Chair over here. I can pull it out if you need me to. Actually, here, I'll just have a seat right there. All right.
All right. This is the matter of the State of Ohio versus Timothy Gordon II. It's case 25 CRB 1229. And you're Mr. Gordon, is that correct, sir?
I'm representing the estate. I'm the executor of the estate trust, and I'm here to settle the matter at hand.
You didn't answer my question.
I am not the all capital straw man. I am the living man.
Well, there's somebody sitting in this chair who's a living, breathing individual,
Yes.
correct?
Yes, sir. And I'm not a corporation like you guys are. I'm not. We do business together.
You
I'm
may
a living
you
man.
may believe that, sir, and
No, that's the
I'm
truth.
not going to try to get you to believe other than what you believe.
Yeah.
But you, according to the record here, is you would be Timothy J. Gordon II,
The living man.
and we're here today on a bench trial in this matter. Are the parties ready to proceed?
The state is, Your Honor.
All right. And Mr. Gordon, you're not represented by counsel.
No, I do not consent to these hearings. I do not wish to contract.
I hear what you're saying, and
Sir,
I'm sitting up here prepared to hear any evidence regarding what occurred
there
in
is no
this
probable cause in
case.
the whole case.
I'm
sorry. I
I'm
apologize.
speaking.
Apologize.
Yeah. And we're going to go to a trial in this matter today. Whether you wish to be if you wish to be represented, you can be represented by counsel.
Nope.
And if you can't afford an attorney, the court would appoint an attorney to represent you.
Here's where the consequences start stacking up. The judge gives him an out: accept court-appointed counsel or hire your own. Instead of taking that opportunity, he questions the competency of the attorney and hints at going after the prosecutor. That's a dangerous shift. Courts take threats, even loosely phrased ones, very seriously. And notice how the judge calmly puts everything on the record. That's strategic. Documentation protects the court and clarifies intent. When defendants reject counsel based on fantasy legal standards, they often end up representing themselves, which rarely ends well. But what's more concerning here is how disconnected his arguments are from the actual charges. He's not disputing facts. He's attacking the legitimacy of the entire system.
Okay, that's your prerogative.
Yes, that's
I don't
all
know
right.
that it's the wisest prerogative, but it is your prerogative. Here's how trials are conducted, Mr. Gord. The state of Ohio, Ms. Yeager, who represents the state of Ohio, will be presenting evidence through witnesses who are sworn. And those witnesses will take the witness stand here and tell the court whatever Ms. Yeager asks of those witnesses. At the conclusion of their testimony, you have the opportunity to ask questions regarding the testimony of the individual, and that's called cross-examination.
Yes, sir.
If you have questions, please make sure that they're